Hello, everyone. This time round, we're talking about the concept of justice as narrative, justice as story. Narrative, of course, is the fancier academic way of putting it. But I think story is a much better term, not only because ordinary people understand more than what it means, but also a lot of First Nations people are now returning back to story as an important part of culture. So I think it's a really useful term to use in a way that broadens the topic of what sorts of stories we tell, from the deep stories of the past through the stories of our mythologies and faiths and beliefs, through to the stories we tell in pop culture or the stories we tell each other on social media. We have a really deeply ingrained notion of justice that comes from this use of story. And this is probably, in some ways, the place where we could have started the term. We could have started with story as the first and most fundamental way in which we understand and talk about justice. But it sort of doesn't make sense until we have a look at what the other ideas of justice are. So I've pushed it back to this point where we can actually contrast the idea of story, this sort of more informal idea of justice, to what we've already learned about how institutions of justice manage the idea of justice, the concept of justice. And one of the important things that we learn is it's very, very difficult to distinguish between the value of different stories. It's incredibly contextual. And, how do we judge the difference between the stories of justice told by Aristotle 2,000 years ago and, Karen on Facebook who's having a complaint about someone or something? They're both, stories individuals tell about justice. And in some ways we want to privilege Aristotle because, Aristotle's a famous philosopher. But, where are all the things that lie in between? Where do we... Yes, I mean, we could probably easily dismiss some of the things that our friend Karen says because they're not well considered, they're not thought out, whatever else. And we could say, well, Aristotle, spent a lot of time developing these theories. They've been tested by other people. Yeah, we can probably see that Aristotle tips the balance there. But not only are we kind of in danger of privileging a certain point of view and certain power structures by privileging what Aristotle has to say, but we are also, this very difficult, who's in between Aristotle and Karen? How do we make a determination of value then? So yes, stories are very, very contextual. They're very culturally derived. And one of the things about the academic study of story is trying to establish the framework by which we ascribe different values to different stories and understand what the cost of valuing one over the other is. And, Karen, our friend Karen's belief about what's just or unjust, to her might be just as burning and just as pertinent to her as an academic theorist. So we can't personally say that it somehow means more to different individuals. But what we can say is that the discourse around story, the reproduction of story, the embedding of story in culture has something to say about its importance, in that bad stories are not going to last. That, a story that's not relevant, that is not resonant with our culture, is not going to be retold. But also the fact that the retelling of story is something that creates that importance of the story. The more we retell it, even if it's a dangerous story, the more we retell it, the more value it gathers, like a snowball rolling downhill. And, sometimes old stories stick around long after their relevance or value to culture continues. And I've referred to in the notes to the story of Medusa. First of all, to show you how culture can really change the notion of what's justice, but also to show how, some of the frankly misogynist assumptions around the Medusa legend are continued. And as we retell that story in culture, we run the risk of reinforcing those kind of values. And, to jump a little bit ahead of the notes, if you're watching this before you're reading the notes, Medusa was a beautiful woman in ancient mythological Greece, and she was pursued by the god Poseidon, who wanted to rape her. And she sheltered in Athena's temple, and he broke into the temple and raped Medusa. And Athena was so angry at what happened that she turned Medusa into a monster. Her and her sisters became the Gorgons, who became so ugly that you could turn to stone by seeing their hideous faces. Now, to modern viewpoints, where we expect the actions of gods or the cosmos or the universe to be somehow just, this is a terrible story. It's a story of, a woman who's punished for being a rape victim, and eventually gets killed by the son of the rapist. Perseus is the son of Poseidon. It's a horrible story with no justice at all for poor Medusa. And worse yet, she doesn't even get to be the hero of her story. Perseus gets to be the hero. She just gets to be a monster in the background. So in many ways, it tells us the difference in the ideas of justice between ancient Greece and now. Not only does it show that, women had a very bad time in ancient Greece, and particularly by the powerful Athenians were considered in a very poor light. But also, I don't think there was an expectation in Greek mythology that you thought the gods behaved in a just way. In fact, I think in an environment where life was very risky, and in the Mediterranean there's storms all the time and earthquakes and all sorts of things that happen that threaten your life, and disease. I think those stories go some way to explain why the universe is unjust, why terrible things happen to people, and it's because the gods aren't very nice people and they do terrible things. And that's not something that the modern mind really copes with out of a sort of a cosmological, mythological background. We want things to be good, and we want things to be just. And as a result, the reinterpretation of those Greek myths in the Percy Jackson books and TV series, we have Medusa and we have Poseidon in there, but we just don't go there in terms of the rape that's in the story. And in fact, many of the modern retellings, particularly for children, do something even worse to poor old Medusa. They say that she's seduced, that they replace the rape with a seduction. She's seduced by Poseidon, and they make her complicit in the crime. So that's the first issue, I guess, I wanted to raise with those stories, is that we have to see them in context. We have to see that cultural ideas of justice shift significantly over time. What we also can talk about is the way that these stories can hang about in our culture, and in ways that are that are not helpful. I mean, the idea that of blaming the victim is very clear in Medusa's story. She was too beautiful. She was raped by Poseidon because she was too beautiful, and therefore it was her fault what happened to her. Now, we do see that same kind of nonsense appear again and again and again throughout the history of laws relating to sexual assault, and we're weeding a lot of them out, and we're trying to change the culture around it, and we've come a long way, but we still have a long way to go. And there are all these little pieces of culture that still reflect these misogynist attitudes of the past. And I don't think anyone's going away and, reading the Medusa legend and coming away and changing their attitude about rape victims, but it's part of this immersion in culture, and it's part of these stories that form the backbone of our culture that we need to be conscious of, we need to be aware of. So when we're talking about stories, it's not just a nice, warm and fluffy kind of, let's go back to the stories and that'll be better than the legal system, because stories can be very dangerous. The other thing is the legal system does use stories in itself. Precedents in many ways are nothing but stories. It's just that there's stories that only tend to get retold amongst the legal fraternity. There's some exceptions. There are a few cases that you can mention, and ordinary people will go, "Oh, yeah, it's that case," and quite often they're sort of civil rights justice cases, and quite often they're the American ones. We don't tend to really know much about the Australian ones, so people will know, Roe versus Wade. It's been a big discussion recently. Many people know about Brown and the Board of Education. Or at least they'll know about the issue of segregated schools in the US. But we know much, much less about Australian cases. I mean, most people on the street are not going to know the case of Bjelke Petersen and the Commonwealth. And that's, just as important a civil rights case as Brown and the Board of Education. And it was a case about whether the Racial Discrimination Act applied to governments. And we had a state government, I believe it was in the 1980s, saying that, what we're doing is racist, but we're allowed to be racist because we're a state government. And the High Court said, well, no, you're not. There's a Racial Discrimination Act, Commonwealth Act. You have to follow that, even though you're a government. Now, that's a really important case, but it doesn't have the same kind of story cachet or coverage in our society as some of the American cases. I mean, Mabo is probably a case that most people know about, and probably, unfortunately, a lot of what they know about Mabo is the News Corp version of what the decision says, which is not actually true. But that's one decision that people talk about, that's a story that's told before the law, that's something we know in culture. But most legal stories, most legal precedents, there's sort of a closed echo chamber amongst lawyers. If you say Donoghue and Stevenson to a lawyer, every Australian lawyer will go, the snail in the ginger beer bottle. Oh, yeah, we know all about that. That's a really important case. It totally changed the way we looked at personal liability. But you talk about Donoghue and Stevenson to anyone else, and no one's going to have heard of it. Or the snail in the ginger beer bottle, which is just as disgusting as it sounds. Okay, so I'm making the loop back to kind of from our cultural ideas of stories back to the ways in which our systems, particularly the legal system, uses stories. And what I want to do is briefly go through some of the different legal theories that discuss the ways in which the law interprets justice. And these are core stories that the law, that lawyers, that the institutions tell themselves about law's relationship to justice, which is generally that law should be behaving in the interest of justice. Now, each of these theories that I want to talk through just very briefly, they're discussed in the materials as well, doesn't just apply to law. They're ideas of justice that apply broadly across society, but they're ones that have been encoded within law and written about in law. There's a body of legal philosophy called jurisprudence. You may have heard the term jurisprudence before, and it's basically just lawyers taking stuff from other areas of philosophy and political thought and importing it into law, because lawyers don't like listening to anyone but lawyers. And you say, this is philosophy, they go, puh, it's nothing to do with us, we're lawyers. This is jurisprudence. Oh, okay, we'll talk about jurisprudence. It's quite amusing, really. So I'll go through these just very quickly and give you an idea that these are ways we explain the relationship between law and justice, but these are also ways in which we can explain our own relationships, the stories we tell ourselves about justice. All right, the first one is natural law. This comes out of a period where Christianity was the dominant culture in Europe, and was very closely tied to political structures. There was a belief in the divine right of kings, which meant that everything the king did was just, because the king was clearly appointed by God, and therefore the king could do no wrong. That got disrupted at the point of Magna Carta. Obviously it got disrupted a lot along the way, because there were a lot of really crappy kings who did a lot of really crappy, unjust things. But the Magna Carta was the point at which the king was forced to concede the British king was forced to concede for the first time that this divine right of king wasn't a total shield of it for anything that he did. But the idea of natural law is that there is a natural order into the universe and that it's a good one. This is very different to the Greeks. The Greeks influenced the creation of Christianity, but one of the things they rejected, and this is where the Judaic influence on Christianity came from, what they rejected was this idea of the gods being petty and dysfunctional. Christianity brought this idea of God being good and the universe being good, and occasionally terrible things happen, but ultimately there's this divine plan. So the idea of natural law, and it's an idea that we still use this day in some areas of law, is that any law that is not aligned to this profound cosmic goodness is not a just law and is therefore not a law at all. And we saw it applied in a quite interesting way in the war crime trials after World War II, where people were saying, well, I did things I was ordered to by the Nazi government, and the government had the power to do it, therefore it was legal and just what I did. And the war crime trials said, well, no, there is a profound natural order, and there's this natural law that meant that the Nazi laws were not laws. They were not valid laws because they were so much out of kilter with the goodness of society. There's a rabbit hole there that we could go down and we could spend the rest of the term talking about, because, if someone's pointing a gun at you and telling you to do something, can you debate moral philosophy with them? Interesting point. But you get the idea. It's this idea that law and justice should be the same thing, and that law should be doing good. Compare this to common law theory. And this is a philosophy that came about with the development of the common law, the development of case law and judge-made law. And basically, we spend a lot more time following precedents than we did referring to religious or moral texts and saying, is this right or is this wrong? We spend a lot more time looking at, is this following the precedent? Is this being consistent? So common law theory displaces the idea of good being this cosmic justice and says that consistency itself is justice. Because we live in an increasingly complicated world, and this was in the Middle Ages, so and the early Enlightenment, so, our world's even more complicated then. We can't really make a judgment call on every case as to what is the cosmic good and the cosmic justice. The best we can do is be consistent. So common law theory, in line with what we talked about previously in terms of justice as precedents, is about that consistency. And you can work that with natural law. If your precedents are behaving in a way that's unjust, you can use natural law to go back and say, maybe we need to change those precedents. But fundamentally, common law theory is about relying on the wisdom of the judges as the custodians of the law and the developers of this ongoing notion of what justice is. It's not a million miles away with what elders in First Nations communities do. This is something that I've only recently kind of been thinking about, and there's not a lot written about, but there's some really interesting comparisons between the judicial process on the one hand and the yarning process in Australian First Nations people on the other. And in some ways, common law theory might be on a way of bridging the differences between colonizer and colonized. But again, another rabbit hole that we could spend the rest of the term talking about. The next theory of law is positivism, and this came out of the age of science, the age of reason, the age of rationality, and it came out of a frustration with the opaqueness of common law to ordinary people, particularly, moral philosophers who said, I don't understand it, I don't want anything to do with it. Jeremy Bentham said the common law is nothing but a heap of odds and ends. It's nonsense upon stilts. So positivists wanted things to be very rational. And in many ways, positivists abandoned the idea of justice altogether. They said law is about power, and whoever has the power can make the laws. And there's no requirement for them to, as long as they're fairly appointed under whatever system of government you have to appoint people in power and to make laws, and they dot the I's and cross the T's making the laws. They have the power to make the laws. The laws are therefore valid. No question of justice required. And that's the kind of thinking that got us into all kinds of bad situations. And I agree, like all these theories all still have validity, and I think there's a certain pragmatism that comes from positivism. And one of the results of it was the next of the concepts we're going to look at, which is legal realism. And this comes out of Scandinavia in the early 20th century. And it's not really a rejection, but more of a refocusing of what we're looking at as legal philosophers and saying most of what we do in law is not about the grand narrative. It's not about good and evil. Even, if you watch Law and Order, you might think so, but most of what happens in law is very mundane. It's every day. So maybe when we should be looking at law, we should be looking at what we call the law jobs. What does law do? And what it largely does is resolve conflicts in society. So legal realism says justice is about good conflict resolution. So again, it's a different sort of story. It's not a story of good conquering evil or power being exerted over all. It's about coming to a solution that's acceptable going forward, that's good for everyone. So legal realism is really big on alternative things like mediation and different ways of getting to the same result that law might not be, in some situations, law might not be the best tool to use. And the last of the theories I'm going to look at is critical legal studies. And this is where sociology and legal studies converge. And this is where a lot of the critiques of power and structure in society started to enter legal thought. So sociology and politics were areas of study that exposed power imbalances in society, injustices in society, getting back to the justice theme, particularly around areas of race, gender, and class, with three big ones for sociology. But of course, there's all sorts of other areas of injustice that we recognize now. We look at sexuality, we look at systemic injustice, we look at generational trauma, we look at a whole lot of different things from a social perspective that law previously said law sits in its little box and the rest of society sits in another box, and they don't really intersect. And critical legal studies imported a lot of these ideas of different values and ideas and fundamental ideas about justice through equality that would then use the existing ideas of equality before the law to say, well, the law has to look at this stuff. If the law says you can't discriminate on someone on the basis of their race or social construction of what race is, because race isn't a real thing anyway. And then you find that the law is actually discriminating against people on basis of the areas of the town that they live in. And it just happens to be that the areas that are most scrutinized and policed are the black or Hispanic areas of town. Then you're finding that the formal rhetoric of law about equality is not being met in reality. So critical legal studies, and we get this in this nonsense about critical race studies that's coming out of American discourse. Critical race studies came out of legal studies, and it came out of a way of understanding equality and moving equality in a more sophisticated way beyond the just ideas of formal equality. We're going to talk about that a little bit later on in the term as well, and we've already mentioned formal and substantive equality. So critical legal studies, it's a mixed bag of different things, but it's basically a way of turning the focus back in on the law itself and saying, right, we accept that the law's stories are around justice and injustice. What does that actually mean? And what does our broader understanding of society mean for that? So anyway, that's a really quick overview of 5 really dominant ways of thinking in jurisprudence. And I think hopefully that will give you an idea of the way in which stories become more useful to us the more they get more repeated, the more people contribute to them, the more these stories become visible than just an individual saying, I think this or I think that. So we get this institutionalization of these stories. And just to finally tie it back to a very original thought there, stories are very powerful, but they can also be very dangerous. And we need to have a really open mind when we look at stories and the way in which stories shape our ideas of justice.